We're looking at the operation of precedent in the Federal High Court, the State High Court, the National Industrial Court, the Sharia Court of Appeal, and the Customary Court of Appeal. If you look at Section 6(5) of 1999 Constitution, you will find the Federal High Court, the State High Court, the Sharia Court of Appeal, and the Customary Court of Appeal as the remaining courts of superior courts of record. You will not find National Industrial Court unless you look at the Constitution, Third Alteration, Amendment Act of 2010. It created a new section 6(5)(cc) that added National Industrial Court as one of the superior courts of record in the 1999 Constitution. However, before we talk about these first three courts, let's first look at the Sharia Court of Appeal and the Customary Court of Appeal. The Sharia Court of Appeal and the Customary Court of Appeal, you realize that they are not normal English type courts. These ones, the Sharia Court of Appeal deals with Islamic personal law, while the Customary Court of Appeal deals with customary law. So by virtue of this, they don't actually apply the adjectival or procedural English law, common law, and so the doctrine of precedents don't apply to them. So for Sharia Court of Appeal and Customary Court of Appeal, the precedents don't apply. Precedents don't apply. However, like Obilade has already argued, and a few other authors have also argued, that by virtue of the fact that their matters go on appeal from the Sharia Court of Appeal and Customary Court of Appeal to the Court of Appeal and then to the Supreme Court, that because they still have to take their matters before the Supreme Court and the Court of Appeal, that there is a need that they should be able to obey the precedents of the higher court, but it's not strictly applicable within these two courts. So that's that for Sharia Court of Appeal and Customary Court of Appeal. Now, but for the Federal High Court, the State High Court, and the National Industrial Court, these courts are basically courts of coordinate jurisdiction, coordinate or concurrent jurisdiction. And the law as it relates to precedents is that courts of coordinate or concurrent jurisdictions don't bind themselves. Now, but we know that by virtue of the rule of precedents that these three courts will be bound by the decisions of the Supreme Court and the Court of Appeal, because those courts are above them in the hierarchy of courts, even in section as it's set out in the Constitution. So these three courts are bound by the two courts above them, but then amongst themselves they cannot bind themselves. Rather, they can only persuade themselves. They can only persuade themselves, but you cannot say that the Federal High Court is going to bind the State High Court, or the State High Court is going to bind the National Industrial Court. We know that the Federal High Court has some exclusive legislation in Section 251. Things like federal government and its agencies, banking, and the rest of them. And the National Industrial Court has some exclusive legislation by virtue of Section 254(cc) of the Constitution, Third Alteration Amendment Act of 2010. Now, they have exclusive jurisdiction in certain things, but they are all courts that are on the same juridical level, and so they cannot bind themselves. That's why, for example, in the case of Umezurike and AG Federation, 2008, the court held that the Federal Capital Territory, the Federal High Court, and the Federal Capital Territory and the Federal High Court of Owerri are courts of coordinate jurisdiction, and as such, the Federal High Court of Owerri cannot give an order that will stop the Federal Capital Territory Abuja High Court from continuing with what it wants to do. And the same thing was repeated in Ozokalo's case that was decided in 2016. Ozokalo and the federal government that dealt with the EFCC thing, is 2016 decision. It was just this year, and it had to do with Imo State High Court giving an injunction to stop a federal high court in Abuja from proceeding with the investigation of former Ccoa, and the court held that it's not possible that courts at that level do not actually bind themselves. So having established that, you will also know that for the courts beneath the Federal High Court, those courts that are not listed in the 1999 Constitution that we said, without being derogatory, are called inferior courts because they have limited jurisdiction. They're under the supervisory jurisdiction of the higher courts, and they also, most of the times, operate by virtue of summary jurisdiction. Now, the inferior courts are bound by decisions of those courts and the courts above them. And you only need to note, for example, that when matters come before the state high court, that the matter might either be a federal matter or a state matter. You know that the Constitution divides the legislative powers into the exclusive legislative list that deals with purely federal matters, and then the concurrent list that deals with matters that state and the other exclusive list. So if the matter that comes before the state high court is a state matter, if it's a matter on, it's just purely a state matter, then the decision of the state high court will only bind magistrate courts and district courts and customary courts within that state. But if the matter that came before the state high court is a federal matter, then you will find out that that federal matter will be, the decision of the court on that federal matter will be binding on all the magistrate courts, area courts, district courts, and every court that is below the state high court in all the states of federation, because it's a federal matter. So that's basically the thing you need to note about the federal high court, the state high court, and the national industrial court. And then finally we'll look at the defunct courts, which are basically the federal supreme courts, the West African Court of Appeal, and the Western States Court of Appeal, and how their precedents will be looked at currently in today's judicial structure that we have, and as well as look at how the decisions of foreign courts are treated within the Nigerian courts.